Hello and good evening, everyone. I am Mansi Ghanekar, working in the Investor Education Department of NISM. NISM is the capacity building initiative of SEBI. We at NISM conduct a wide range of activities at various levels with the objective of improving quality standards in the securities markets. At NISM, we work in five broad areas: long and short term academic programs, certifications for market intermediaries, e learning programs, training programs for working professionals and academia, and various investor education initiatives. We introduce a series on succession planning awareness comprising 5 episodes scheduled on every Wednesday of April 2026. The previous episode focused on the topic Understanding Wills and Estate Distribution. Today, we present the fourth episode of the series on the topic Planning for Incapacity and Minor Children by Mr. Deepak Jain. Mr. Deepak Jain is the founder director of American Academy of Financial Management India and the managing director of NextGen Estate Planning Solutions Private Limited. Now, I would request Deepak sir to begin with the session.
Thank you, Ayman. Thanks a lot. I hope I am audible and you can view my screen.
Yes, sir, you're audible.
Okay, great. Good afternoon, everyone. We start this session, which is on planning for incapacity and minor children. So, when we talk about inheritance planning, succession planning, people think estate planning or inheritance planning is only about death. But it is also about incapacity, medical decision, and protection of minor children. That's a very, very important subset of inheritance planning. It's not only what happens when I die, it's also what happens if I am there but no longer in control. No longer in control, right? So, what happens to you or your wealth or your family if you are alive and unable to decide? Who will manage your money? Who will take the medical decisions? And who would care for your minor children? Those kind of questions I will answer today in this session. This session is about incapacitation planning as well as protecting minor children, right? So we'll be talking about these kind of document, durable power attorney, letter of guardianship, living wills, springing durable power attorney, etc. So let me start the session by asking you a question. Does this concern you? Risk of loss of control over your assets in event of your disability. Suppose you are in coma, you are mentally incapacitated, you have Parkinson, you have dementia, right? Those kind of diseases you have. In such situations, who would be able to operate your singly operated bank accounts, mutual fund holdings, fixed deposits, any property you have rented out, who will be able to take rent on your behalf and renew the rent agreement? And what have you done for that? And it's a bigger risk than dying. Because if I die, my family suffers. If I'm incapacitated, both me and my family suffers. So how have you ensured access and control transfer in case of your disability? And what can you do for that? So what can you do for that? What can you do for that? You can create a document which is called a springing durable financial power of attorney for incapacitation. This is a specialized document created for incapacitation planning. Now, what is a power attorney? Power attorney is a legal document through which one person gives another person the authority to act on their behalf. So when I authorize somebody to act on my behalf, the legal document containing that authority is called a power attorney, right? So power attorney is an agency relationship. There is a principal who gives the authority, and there is an attorney holder or agent who acts on the behalf of the principal, right? And this document which contains this agency relationship is called power attorney. Now, the question is, what can a power attorney cover? Depending on the wording of power attorney, a power attorney holder may be allowed or may be not allowed, not compulsory, but this is an option to do financial transactions, do property documentation, rent collection, bill payment, representation between offices or institutions. So you can give power of attorney to somebody to represent you in front of an income tax officer. So that's a power of attorney. Execution of documents. You can allow somebody to sign on behalf of you for selling a property. Right? So those kind of things a power of attorney can hold in general. We are talking about a springing durable power of attorney. But before that, let me give you some facts about power of attorney. Power of attorney which has not been executed correctly holds no value. So it has to be executed correctly. It has to be made correctly and signed correctly. And if there's a registration requirement, maybe registered correctly, right? It is always advisable to get a power of attorney registered because it improves the legal validity of the document. Now, as per law, if a power of attorney only consists of financial assets, registering it is optional. But if it contains any real estate or immovable asset, registering it is mandatory. But if you ask me what is the practical thing, I would say any power of attorney, whether it contains financial assets transactions or a immovable property transaction, both need to be registered. That's better. Right? A power of attorney may be needed to be authenticated by a notary public even if you don't register it. Right? Right? This I have covered. How can you terminate a power of attorney? Suppose I have given a power of attorney to somebody and I want to withdraw it. Right? Generally speaking, power of attorney can be cancelled by the principal by giving a notice to the attorney holder that I am revoking the power of attorney. But here the challenge is, how do I inform the institutions where this attorney holder has already produced their power of attorney given them and as is acting on my behalf? So it is my duty to inform all these people out there that I have revoked. So suppose this person has given my power of attorney to my bank, right? To a AMC, to a broker. I have to inform to all of them in writing that I am withdrawn this power of attorney and please do not act any further on it. I can even force the attorney holder to give me a list of places where he has used the power of attorney so that I can inform. But terminating a power of attorney is a little painful task, right? Okay. Now, what are the different types of power of attorney? Let's talk about that. What are the different types of power of attorney? Let's talk about that. Right. There are two power of attorneys. There are different types of power of attorney depending on their objective. What purpose I have created power of attorney? You can divide the power of attorney based on their purpose. General power of attorney, financial power of attorney, healthcare power of attorney. There are different types of power of attorney. Right. And second way of classifying power of attorney is based on their technicalities. What legality do they contain? So there you have general power of attorney, you have a special power of attorney, and you have a durable power. So let me first talk about type of power of attorney as per their objective. As per their objective, there is a general power of attorney. General power of attorney gives vast power to the attorney holder to act on your behalf if you have given somebody the power of attorney. So I authorize my wife and I give her a general power of attorney. The reason is in case something happens to me, this my wife can do things which I allow, and there are varied things which I allow her in this power of attorney. Right? So that's called general power of attorney. There is a healthcare power of attorney where you allow somebody to take healthcare decisions on your behalf. Now, healthcare power of attorney is a special power of attorney. Why? Because I only allow healthcare decisions, not financial decisions in a healthcare power of attorney. Right? Then there is something called financial power of attorney, which allows somebody to only take financial decisions on your behalf, to operate your bank accounts, to sell your mutual fund holdings, right? To pay your insurance premiums, right? To redeem different investments. So that's kind of power of attorney, right? So what kind of activities you do in a power of attorney? Paying bills, making investment decision, paying for healthcare, housing, etc. are decisions you can allow in a financial power of attorney. Now, types of power attorney as per their technicality, and this is important for you to understand. First is special power attorney. Special power attorney, you ask the person only a special thing. So I have a flat in Calcutta, I am in Delhi. So I give a special power attorney to a friend of mine or a lawyer of mine in Calcutta to sell that flat on my behalf. That's a special power attorney. It's only for that purpose, and for that time it remains there. After that, it automatically gets revoked. So once that activity which I have allowed is done, the special power attorney would itself terminate. Second is durable power attorney, and this is very important for us for this session. A normal power of attorney assumes that the agent or the attorney is acting on behalf of the principal. I repeat, a normal power of attorney assumes that the agent or the attorney is acting on behalf of the principal on the instructions of the principal. Because the principal cannot be physically present, he is guiding the attorney holder and the attorney holder is taking the action. My problem is when I'm incapacitated, can I give instructions? If I am in coma, I am paralytic, I am mentally unsound, can I still give instructions? No. That means normal power of attorney would fail in case I am incapacitated. But I want to create a power of attorney which is alive and legal in case I am incapacitated. That's the reason we are doing this, including it in this session. Now, if I create a durable power of attorney, I am giving the right to the attorney holder to take decisions on my behalf. So there is a clause of durability added to the power attorney which says even if I am incapacitated, this power attorney would remain valid and this person whom I am authorizing is allowed to take financial and other decisions which I am allowing this person to do in this power attorney. That's called durable power attorney, right? Right. So this is what we have discussed, right? Now, things to remember for a power attorney. One, power of attorney cannot survive the principal's death. Suppose I have given a power attorney to my wife. Moment I die, power attorney ceases to exist. Also, a power attorney cannot survive the agent's death. If my wife dies and I have given her the power attorney or she becomes incapacitated, the power attorney is invalid. So either the principal or the agent, their death causes the power attorney to be end or terminated. Power attorney can be cancelled. This I have already told you. In case the agent and also institution where the agent acted should be notified in writing. Whom do you can you choose to become a power attorney holder? An individual with high integrity who is always likely to act on your behalf, a well-wisher of the family, should be appointed as a power attorney holder, right? And any suspicion of wrongdoing should be reported to law enforcement agencies in case you think your attorney holder is doing something wrong. Before I end this, I should also tell you what is springing durable power attorney. What is this springing? A normal power of attorney becomes active the moment I have created it. But in a springing durable power attorney, I am saying this power attorney would only be activated once I am incapacitated. So I create a springing durable power attorney for incapacitation because I don't want that person to act on my behalf today. I want that person to act on my behalf if I am incapacitated. And to ensure that this person is only able to act when I am incapacitated, I put a clause in this power attorney saying that the attorney holder would have to produce certificate from one or two doctors certifying that I have become financially incapacitated, unable to take financial decisions. When I add this clause, it becomes springing durable power attorney. And I would always advocate that you create a springing durable financial power attorney for incapacitation so that somebody is allowed to act on your behalf in case you become incapacitated, right? Now, recently, SEBI has introduced a concept, a different kind of nominee, which is called the incapacitation nominee, which is allowed in demat accounts and mutual fund folios, right? That is a very, very important and welcome step taken by the Securities Exchange Board of India. It applies to demat accounts and mutual fund folios, right? Where you can register a nominee out of your nominees to operate these accounts on your behalf in case you become incapacitated, right? So incapacitation nominee is a very, very important thing which you can use to allow somebody to operate your demat accounts, your mutual fund folios, and other security market instruments, which is now allowed by Securities Exchange Board of India, right? It is only meant for physical incapacitation, where the investor is unable to sign. The investor must still have capacity to contest. So if I become mentally incapacitated, this SEBI incapacitation nominee or incapacitation nominee cannot be used. It can only be used if I'm paralytic, right? I am physically disabled. Then this gets activated and that person can, uh, the nominee such appointed can act on your behalf, right? And there's a whole process, including medical documentation, etc., required to enforce this nominee, right? There are some features you must understand before you think about the SEBI incapacitation nominee, which is allowed in demat accounts and uh, in other such mutual fund folios, etc. The empowered person should be one of the registered nominee and not a minor nominee. Investor can set transaction limit in percentage or value. I allowed my incapacitated nominee to only withdraw 10% of the total asset or maximum 5 lakh rupees per month. I can do that. Sale redemption proceeds only go to the investor's linked account. It doesn't go to the incapacitated nominee's account. It goes to the person who owns these assets account, right? Changes such as bank account, email number, mobile number are not permitted through this route. This facility is helpful and it should not be presented as a substitute of broader financial power because this only physical incapacitation is covered and only SEBI registered investment options are covered here, not the entire financial gamut. So it is not a substitute, but it adds to the value of a springing durable power attorney. You should always create a incapacitation nominee in all your mutual fund folios and demat accounts, right? And uh, uh, your AMCs and your depository participants have an option to appoint that, right? So it's useful for limited security market continuity. It's not a complete solution for incapacitation planning, right? Chaliye. Now I come to my second concern. How many of you have minor children, children less than 18 years of age? Question is, in case you and your spouse pass away while your child is a minor, who will get the custody of your child? And it does not go to your parents or your spouse's parents. It does not go to your brother, your sister, her sister, because 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 as per the Indian Guardianship and Maintenance Act, there are only three types of guardian, which we'll be discussing later. And parents are the only natural guardian. In absence of parents, the other guardianship gets triggered, and your parents and siblings are not the guardians. So let me talk more about guardianship. So what is guardianship? A guardian is a person appointed to look after another person or his property. So he assumes the care and protection of the person from whom he is appointed as a guardian. Guardian can take all legal decisions on behalf of the person and the property whom he is taking care of, right? Uh, Guardianship is generally given for minority of a person. But in case a person is a special person, specially able, disabled person, it can be given for adults also. And we'll discuss that also, right? If somebody has physical and mental deficiency who is unable to take care of himself, that case also guardianship can be given. Right? That's called conservatorship. Guardianship of adult person with another adult person. So type of guardian as per the Indian law, first is natural guardian. And it is only parents who can be natural guardian. In absence of parents, society becomes the guardian of the child. And society is represented by the district judge. Now the district judge decides who gets the custody of the child, of the minor child. And that choice of the judge might not be same as the parents. For that purpose, the law has a provision of a third type of guardian, which is called testamentary guardian. Each parent is allowed to appoint a guardian of their child while they are alive through a document called letter of guardianship. The document is called letter of guardianship, right? So when it comes to natural guardians, you should understand their ability and disability, right? A natural guardian can take all action that will benefit and protect the minor or his property, but even a natural guardian cannot sign personal contracts on behalf of the minor, right? A natural guardian cannot sell, mortgage, or give any part of the minor's property, lease his property for more than 5 years. So even parents cannot sell a minor's property without court approval. They cannot lease a property beyond the child turning major, 1 year after child turning major. So if my child is 18 years of age, maximum time this lease should end is by the age of 19 of the child. Beyond that, I am not allowed to create even a lease or a rent agreement. That is the disability of a parent for the property of a minor child, right? So to avoid the situation that a minor is left without a guardian and the parents have passed away, we create a document which is called guardianship letter. It's called letter of guardianship. Letter of guardianship is a document that allows a person to hand over the guardianship right of their children to a different party. So me and my wife together create a document which says in case both of us pass away while the child is minor, this person will get the guardianship of my child. So that document, the legal document where the guardianship is transferred using the testamentary guardian option inside the law, that document is called a guardianship letter, right? So it and this guardianship can be given temporarily or permanently. Permanently is when both of us pass away. There could be a situation where both of us are alive but incapacitated. I can then also give guardianship temporarily to another person, right? So it contains option for both permanent guardianship or a temporary guardianship, right? You can put conditions inside this letter of guardianship what the guardian is allowed to do, right? I can say they're allowed to take this much money out of the child's asset every month for their living expenses. And these are my values which they need to help me transfer to the child of mine, right? They can take decisions on where the child would study, right? They can take decisions uh, uh, on child's religious beliefs, etc. Those are kind of things which I'll build into the guardianship letter, right? So there are some situations where guardianship letter is required. The guardian, uh, the parent is in jail or similar situations. Both the parents are in jail. One parent has passed away, second has been incarcerated, and so you might require a guardianship letter. original parent or guardian will be physically absent for short period or permanently, you require a guardianship letter. So those kind of situation, the guardianship letter is required, right? So what happens when people don't leave a guardianship letter? When parents don't leave a guardianship letter, the court will decide the guardian based on the best interest of the child, right? Best interest is a criteria court use when they select a custody of the parent in case of a divorce situation. And it is very, very, one, mentally torturing for the child, and second, the parent's choice does not become the guardian. And I have seen cases where instead of appointing individuals, the court have appointed institutions as guardian, because they say the ultimate duty of taking care of the child is with us, right? And we want to put the child at a place where we can check whether the child has been taken care properly or not. And where can they do it? Where systems are in place, where processes are in place. And where are processes in place? In institutions. And what do you call those institutions who take care of children whose parents are not alive? You call them orphanages. So would you like your child to go to an orphanage in case both of you pass away while the child is minor? And for that reason, I always allow, please create a letter of guardianship. And you should know there are two types of guardian you can appoint in a letter of guardianship. One is guardian of person, second is guardian of assets. Guardian of person will get the custody of the child. Guardian of asset will get the money of the child. And you can give one person both the asset and the custody, or you can give it to different people. So, in your opinion, what is better? I- Is it better to give it to different people, or is it better to give it to the same person? As such, there is no rule about it, right? But my first option would be to give it to different people. My brother has the custody, your brother has the money. And those two people keep check on each other. But problem here in this situation is if both of them have a disagreement and start fighting, my child would suffer. So you have to carefully decide whether guardian of person and asset should be same or different. I can make, suppose I have a couple, so I can make the mother the the wife the guardian of person and the husband the guardian of asset. That also I can do, right? So those are things which you have options to, right? What should be in the letter of guardianship? Name and contract information of all parties involved, including the guardian, their parents, the child, right? Uh, whom are you appointing the guardian? In case this person you are appointing the guardian is not ready, willing, or able to become the guardian, who is the successor guardian? So I say your brother is the primary guardian and my brother is the successor guardian. In case your brother is not doing it or ready, not ready, willing, or able to do it, my brother becomes the guardian. That I already put in that letter of guardianship, right? Additional condition relating to termination of guardianship arrangement. One thing you should remember is when you appoint a guardian for a child, the age of majority of that child changes from 18 to 21. Now this child would turn major at 21. I can set conditions that on termination of guardianship, the guardian will have to perform these tasks. So suppose my child became an orphan at 12, right? 12 to 21, this person took care of my child and took care of the money. On termination, these are three things this person would have to do, including maybe giving my child whatever, where he has spent his money, what kind of asset did he receive from me, and all those stuff, right? So those kind of conditions I can add, right? You can add the scope of rights and authorities of the guardian, right? So you can tell the guardian this kind of uh, uh, upbringing I want for my child. No, suppose I am a Hindu person, so I can ask that my child should be raised as a devout Hindu. That's my wish for him, right? So those kind of instructions you can add. Uh, the guardian is not legally bound to heed to those instructions, but those become a guiding principle, right? So those second, I can have a guardianship letter which allows my guardian to further appoint guardians, or I may restrict that power to a guardian. So in case you are not able to take care of my child, you can further see who is the next best person to do it and you can appoint it. Or I would say if you are not able to do it, this is the person who will go. So those kind of things I can inbuild into a letter of guardianship. So it's a very, very important document to create for children, people who have minor children, because your biggest asset is your child. And today you have left them unprotected. Now I cover a very important part of guardianship, guardian of adult with disability. So I meet lot of couples who have special children. Problem is, tomorrow when the child turns major, will the parent still be the guardian of the child? Legally, no. So I have a child with autism. He turns 18. Moment he turns 18, the parent cease to be a guardian because the child is not minor. But this person requires a guardian because they'll never become, they'll never have the capacity to contract. For that purpose, there is a provision in the law where you can employ guardianship of this person under the National Trust Act, right? Which is which is basically you have to apply guardianship at a local level committee, which is appointed by the district collector, and file a application in Form A, and all of this is done online. And they call you for in front of this committee, and they appoint guardian. You guardian, right? And this guardianship can be taken in a single name, or couple can take it jointly. So it's a different thing altogether. But what you need to remember is, if you have a special child, or if you know people who have special children, tell them please take the guardianship of the child once he turns major through this act of National Trust Act. Very, very important, right? Who should be a guardian? World's most difficult task is to choose a guardian for your child. That's the most difficult task for a parent. Whom do I trust to take care of my children in case both of us are not there? Right? How to choose a guardian? That's a very, very important question. Right? Problem is, some people would become offended if you are not chosen. Others may not have the capacity or the capability of becoming the guardian. My second problem when I create letter of guardianship is, primary guardian, I can tell very clearly you are the guardian. How do I tell the successor guardian that you are my second choice, not the first choice? Right? That's very difficult telling, right? So, should you choose as a guardian, right? As I told you, you can choose two people, guardian of assets and guardian of person. Principle.
Hello, hello.
Yeah. Can I continue?
Yes, sir, you can just share your screen because
Yeah,
we
yeah.
can't. Yes.
Just a minute.
Ah,
So, I continue on guardianship. So one hard thing which I have learned over the period of time is, I always ask parents before appointing a guardian, if your child age is more than 10 years, ask the child. And in many cases, I have found that the choice of parents and the choice of child is not same. And the major reason for it is people's behavior with your children in front of you and behind you is different. And child has faced that behind you behavior of people. So their choice might not be the same as your choice. In that case, generally speaking, I would say give preference to child choice, right? Because that whole family has to accept the child, not an individual. So this was about letter of guardianship. Now I go to the next part of it. I'll give you a situation. I am sorry I keep giving you these kind of situation. My job is such. Situation is suppose you are brain dead on a ventilator, less than 5% chance of recovering, but doctors keep you artificially alive. Under that situation, what is the risk to you? First risk is you are in lot of pain. And pain for what? You're already dead. Second risk is your wealth would slowly but surely start going to a doctor, nursing home, or a hospital. Can you do something about it? For that situation, we create a document which is called living will. A living will is a document that permits a person to determine in advance what course of treatment should a doctor undertake in case they reach a stage where prolonged treatment of life support would result in suffering. So I can create a legal document which says, in case I am on a ventilator for more than 10 days, switch off the ventilator, keep giving me painkillers. That is legal in India. So you see, it's called euthanasia. One is passive euthanasia, one is active euthanasia. This is passive euthanasia. When you withdraw life support and you legally do it, the document which enables you to have passive euthanasia performed is living will. So there was a famous Supreme Court judgment in March 2018 which said right to die with dignity is the fundamental right of every Indian. So there is an NGO by the name of Choice Foundation. They went to the Supreme Court to with a petition that living will should be allowed in India because a person who is in a permanent vegetative state uh, suffers because of this this option not being available with the doctors and this person to end that life. Then Supreme Court said right to die with dignity is the fundamental right of every Indian. And they added it to the Article 21 of the Constitution, which is right to life, where they said a person can create a document which specifies conditions under which life support should be withdrawn from them. So I can say if I'm more than 10 days in a ventilator, less than 5% chance of recovering, please switch off the ventilator, keep giving me painkiller. That's a legal document in India today, right? So with this judgment, right to die with dignity is recognized as a fundamental right in India. What are the requirements to create a living will? The person creating a living will should be of sound mind, capable of communicating his or her decision clearly. So that means you can only create a living will when you have not reached that situation, right? You can't do it, cannot be an afterthought. It's a voluntary process. You cannot create a living will under pressure, influence, and coercion, etc. Right? The living will should contain a paragraph or a clause saying that the person who is creating the living will has understood the consequence of the will. So he knows that life support will be withdrawn under these circumstances. right? The ability to give instruction is another thing, right? So when can this living will be revoked by the person who is creating? That should be clearly mentioned in the living will, right? Living will anyhow should be in writing, right? And clearly specify conditions where the treatment should be withdrawn, right? The living will must be signed by the person making in presence of two witnesses. Countersigned, countersigned by two witnesses. Now, this countersigned by jurisdictional judicial magistrate has subsequently been uh, removed as a requirement by Supreme Court in a later judgment in 2023. Now, only if you get it notarized, it becomes valid. So, if I want to create a living will, I first appoint a person who decides whether that situation of implementing the living will arrives or not. So suppose I say in my living will, my wife will decide if that situation is arrived, and based on her instruction, the treatment should be given. So the decision to withdraw the treatment is with my wife. That's one way of creating. Second, I can say if that situation is arriving, it is not her decision. This has to be done. She'll just inform and you will have to do it. There are two ways of doing it. Second, I can decide what kind of treatment is allowed and what is not allowed. So I can say artificial resurrection is not allowed. Painkillers are allowed. So I can set those conditions. Today, if you want to create a living will, you create this document, appoint this guardian or relative authorized to decide or inform the doctors. You sign it in front of two witnesses and get it notarized. Even a notarized document becomes a valid document. But there is a state called Maharashtra in India which has appointed custodians for living wills. So if you are living in Maharashtra, there are more than 280 custodians across Maharashtra where this notarized copy can be deposited, right? And these custodians are appointed in the municipal corporations. And then it becomes in the custody of the government of India or a local body controlled by government of India. So then it becomes even more powerful. So in all places in India except Maharashtra, a notarized document is enough. In Maharashtra, you can do a step ahead of notarization and get it, give it to the custody of the custodian appointed in the municipal corporations across Maharashtra. Then it becomes even more easy to implement the document, right? Under what circumstance living can be implemented? When the condition mentioned, when you become terminally ill and despite treatment, there is no hope of recovery. The treated physician or doctor is made aware of the living will. He has to ascertain the authenticity of the document and then he acts upon the document, right? He creates a medical board who checks whether that condition is arrived or not. And they have a whole list of requirement that the board should have three experts, one from general medicine, cardiology, neurology, psychiatry, and oncology, and with these many years of experience, etc., etc. This board then says yes, this condition is arrived. Suppose the board says no, it's not arrived, and the relatives think differently. Then they can go to the high court, and the high court constitutes a division bench and a medical board to decide whether that situation has arrived or not, right? Why why living will is so important? Because first it reflects or respects a patient's human right and their ability to reject medical treatment. I refuse to rot on a bed. मुझको बिस्तर पे पड़कर सड़ना मंजूर नहीं है. ये लीगल राइट है इंडिया में एंड यू कैन एनफोर्स दिस टुडे इन इंडिया by creating this living will. It helps medical professionals take difficult decisions, whether to terminate or not. In fact, it helps family members take difficult decisions, right? Knowing what the patient wants means that doctors are more likely to give appropriate treatment, right? A patient's family and friends don't have to take difficult decisions. Living will is a very, very important document which we should be aware of and we should create, right? So I have talked about three major documents in today's session. First is a springing durable financial power attorney. Then I talked about incapacitation nominee, which you can a point in your demat accounts and folios, all uh, because it's a facility allowed by Securities Exchange Board of India to appoint a special nominee for incapacitation and special only for physical incapacitation. Third, I talked about letter of guardianship for minor children, and lastly, I talked about living will to take care of situations where you are terminally ill in a permanent vegetative state, and any prolonging of life would be detrimental to you and cause you only pain. Right. So we are open for question and answers. Right. And if you have any question and answer, please put it in the Q&A section. And Sahil, you can run the polls now.
Sure, sir. Yes, first poll is live. So there are few questions in Q&A. I think you can address those questions.
Yeah, yeah, yeah.
Uh,
So Rajesh Minocha ji has asked a question: can we have a combined power attorney, general, financial, and healthcare, especially when it is the same person to generally the power attorney you create would have both financial power attorney and other things. In India, there is no healthcare power attorney as such today. So this is more of a US concept, healthcare power attorney. India, you don't have a healthcare power attorney. You can have a living will, which is only for cases of terminal illness, right? A springing durable power attorney, Ashish ji, is generally a general power attorney. Testamentary guardian can be a person who is mentally sound and major. It can be any relationship with the child, doesn't matter. Power attorneys are registered in the sub-registrar office. So please keep on uh, doing the polls. They give us good data for further sessions, and we know what you think about. Right? So please continue appearing for the polls. So where to register a power attorney? Or sub-registrar office. Right? That's the place to register. So you can create a primary power attorney holder agent and a successor power attorney agent. That's possible. First to my wife, and if she's ready, not ready, willing, or able to act, then my elder son. You can have that hierarchy created. That's allowed. In case you have a autistic child, right? The guardianship of that child you have to take from the under the National Trust Act by the district collector's special committee. So we are only talking about guardianship in this session today. But please, I have already told you that a special child trust should be created apart from guardianship so that the parents can leave the financial security of the child behind. So in the next session, when I discuss trust, I'll be talking more on the special child trust and other kind of trust. So you can create a joint attorney, right? But uh, generally, it's not advisable because in case both of them have a disagreement, the family and me suffers, right? Uh, you should give it generally to single person to decide. But yes, you can have successor or joint, it's allowed. So once you create a power attorney, it's better you inform the person that I have given you a springing durable power attorney under these circumstances, and this is the process you have to do before activating this power attorney. Because it has to have a doctor certificate, and you can even specify what kind of doctor has to give that certificate. You can say the doctor should be from a listed hospital on stock exchange, so that a normal doctor cannot be used, and there is no hanky panky in that. So if you have a child with a mental incapacitation and that child has turned major, the parents are no longer legally guardian. They are not the legal guardian because the child has turned major. Unless you go to the go file an application under the National Trust Act go to the district level committee appointed by the district magistrate, and then get the legal guardianship of the child. Then only you can operate their bank accounts, sign documents on their behalf and all those stuff. Dharmenji, living will and springing power attorney are two different documents. Springing power attorney allows somebody to operate your financial assets. Living will decides the course of treatment in case you are terminally ill. So those are two different documents. So generally, the person who is the see custodian would generally be a government official. So you take the doctor certificate that this person is terminally ill, so we need a copy of the living will. So they'll hand it over to you, or they will send it directly to the treating hospital, which is even better. A living will need not be registered, Sumiji now. Only notarized is valid. Selling a property through a GPA is okay, but buying a property only on GPA is not good. Uh, GPA should authorize a sale deed to be made. Just thinking that because you are a GPA holder, you have bought the property, that's the wrong thing to do. So if you have a autistic child, there are two, three things you should do for taking care of the child. First is, in case the child turns adult, you have to be appointed or make an application to be appointed as a legal guardian of the child. Second, create a special child trust and transfer money which you want to leave for the child to that trust today. Don't wait for tomorrow, right? Because date of death is not clear. Nobody knows the date of death. Second, second, this trust, you should look at trustees after both of you. You husband and wife are there till the parents are there. And I always say, when you create a trust like this, make a provision of the head of the institution where the child would be kept after both of you as one of the trustees with very limited powers. Right. Apart from that, you create a document which is called letter of wishes, which is a sort of manual for the child. So when you die, the information which you carry for your special child also dies. So if you have created a professional document stating the information about the child, like what does the child like, what does he dislike, what kind of treatment should be given to the child in case he has a medical emergency, what is he allergic to, how much work can he or she do himself or herself, and how much do they require uh, uh, assistance for. Those kind of instructions should be created in a document very clearly, right? So that if the next person who becomes a guardian after both of you has at least that information and they don't have to discover it over time. Letter of guardianship, Rishika ji, is always better to register it. Although registration is optional, but it's always better to register it, and you can register it just like a will. Hemji, a grandfather can create a trust or will in favor of grandchildren for their education and other expenses. Trust is even better than a will because there you can control the use of assets even after you have passed away. So, Prakashji, this living will is created while you are perfect, right? You can't create a living will when you have reached the stage where you can't communicate, you are not do this. Then it's not a legally valid document. It can only be done in that situation, right? So, I have covered all the questions, Sahil.
Yes, sir.
Yeah,
So I'm launching our last poll, which is
yeah,
poll fifth. Then we'll launch a feedback questions poll.
Yeah.
Yes.
Yeah. So now we'll have those feedback questions. Please, uh, please give the feedback so that we can arrange more such sessions for you and we know what you want from us. There are 5 questions. Please attempt all 5 and give your views on all 5 of them.
So yes, I think now we can conclude the session. As I can see, 50% plus attendees has means took part in the feedback question. Yes, and also related to Q&A, you have addressed almost all of the questions which were asked. So let me just also Rinku is appreciating your session, saying excellent session, Deepak ji.
Thank you.
Yes, yes. So yes, I think now we can conclude our session.
Thank you very much. Thanks a lot.
Yes, thank you so much, sir, again for your time and knowledge. And also, I will request all the attendees to join in for the fifth and last episode of the series, which is scheduled next Wednesday, that is 29th of April. So yes, do join for that session as well. Thank you. Thank you again, sir, for your time. Thank you so
Thank
much.
you very much. Thanks a lot. Thank
Thank
you.
you, sir.
Bye.
Now I request IT team to